Hello and welcome to Meet the Expert, our monthly opportunity here in the Recruiting Gym to bring an expert in to talk about a topic that they're passionate about. I'm Angela Cripsey, MD of the Recruiting Gym, and today we've got Theresa Mimnagh from Lawspeed, and she's going to be talking about navigating change, which pretty much is a constant at the moment. They always say that, don't they? Change is a constant. How are you doing today, Theresa?
Very well, thank you. And thanks for having us on today, Angela. First time we've worked with you, so it's a really, really welcome opportunity for us.
Yes. Now, Lawspeed, I worked with getting on for 20 years ago. I used to be co-chair of the Recruitment Society, and they used to come and do talks for us then. We'd put on an event every month, and Adrian from Lawspeed would come and share his knowledge. So this is full circle, and it's, like you say, it's been a long time. So really appreciate you coming along and talking today, because the topic is what recruiters need to know about the new employment rights bill, which I've seen lots of talk. I mean, lots of WhatsApp groups, everyone's talking around. So I'm really looking forward to your presentation to find out more about how this is going to impact our recruitment industry. But before we get into that, if you could introduce yourself and tell people who you are and what you do.
Hi, so thanks very much, Angela. I'm Theresa. I'm a director of Lawspeed. Some of you may already have come across me. I've been assisting recruitment companies for almost 20 years now with Lawspeed. Lawspeed's been going for more than 25. So we talk to recruitment companies day in, day out about the issues, and I probably could talk about recruitment law issues all day long. But the Employment Rights Bill is definitely, you're absolutely right, it's definitely causing lots of discussion, bit of fear, bit of worry about how it's going to work out. So it's definitely a subject recruitment companies are talking to us about all the time at the moment.
Yeah, no, definitely. We had a conversation in the green room beforehand. I used to train, at the time there were 14 different acts that impacted the recruitment world. But about 10 years ago, I had to put my hands up and admit defeat. For 25 years, I'd been keeping up to date with all the legislation, but it just kept moving so fast. And it wasn't my day job. It wasn't what I was meant to do, but I did love training it. So again, I'm really looking forward to hearing this information. And then we can relate it to recruiters' life and the impact it's potentially going to make. Can we just get a clarification, first of all, of the fact that it's a bill? What's a bill?
So it's been introduced to Parliament. It's the first draft, in effect, of what the law is going to be. So there was this commitment from the new government that they would do this within 100 days. And they did. They just about made it within the 100 days. I mean, I think it was 97, 98. So it's
good that they kept their promise, because we're not used to that, are we?
Yeah, no, it's very, very fast. It's very fast for the passage of a piece of legislation. But it's effectively the first draft. It's got to go through all the parliamentary stages before it becomes an act and before it becomes law and is actually implemented, and we need to deal with it. But it's important to know about it now, because now's the time that we can try and shape it and try and understand where we need to plan moving forwards, but also where we as an industry maybe need to push back and say, this doesn't necessarily work very well for us, or it could work better, or here's the problems we first foresee, and just enable us to help shape the law so it works for us rather than becomes a hindrance.
Yeah, I don't think we always think about that we have the opportunity to help shape these acts before they come in. Certainly, politics wasn't something I was necessarily interested in my 20s and 30s, maybe even my 40s. But it's something that's part of my daily life now. We run a podcast called Hiring Happenings with a Pestle Twist, and the P is political. So we've done 2 sessions of that, one UK focused, one global. I'll get the links in there for everyone as well. So yeah, these big topics and the impact it can have on our lives, to be able to help shape it beforehand. That's why we want to share this information, because yeah, you do have a voice, and we have people within the industry that will take that to Parliament for you. So we want your ideas, we want your information, and certainly if you know this isn't going to work, because we've been there before, haven't we, Theresa, where a new law comes in. Where did that come from? Yeah, didn't really think that through, did you? So
It's one of the things at Lawspeed that we kind of pride ourselves on is we take a slightly different approach from a standard law firm, that because we're recruitment specific and we only work in the recruitment and related industries, we're so specialist here that when there is legislation, we do like to talk to government. We talk through our role with the Association of Recruitment Consultancies. We talk to government once a month along with other trade bodies.
Brilliant.
And we do have opportunities to say, this is where we foresee problems. This is where we can see it can work for the industry. This is where it doesn't. And sometimes the government really does need to hear that, and they like to hear it.
Well, I've heard rumblings over the last couple of weeks when I've been talking to people that have had sort of an ear with the government. And the comment was, there's adults in the room. There's people that actually want to do something. Now, it might not be what we want them to do. They do want to do something, though, but they are willing to listen. That's the feedback that I've been getting. Would you say that that's similar experience for your monthly meetings?
Yeah. There is a lot of competing interests at the moment of, the need to protect vulnerable people in society and the need to protect employers, because there is some exploitation out there, but it can't be at the expense of a lot of the industry that actually work really well and don't have these issues. So it's about us getting a proportionate piece of legislation that reaches its intention of protecting the vulnerable, but without making it too administratively burdensome for us, or making it so that actually we can't provide the valuable service that the recruitment industry does provide to this economy.
Wow. Okay. Well, I'm sure we're going to have some questions. So if you're on LinkedIn Live or YouTube or Facebook, put them in the comments. I'll be zooming around while Theresa's talking. If you're here on Crowdcast, put it in the chat. We're aiming to have around 10 minutes at the end for questions if there are any. But if it is pertinent to what Theresa's saying, then feel free, and I might interject with one of those as we go along. So we'll see how that goes. So I'm going to pop you down the bottom. I'm going to bring the slides in. Let's see. Crowdcast is usually pretty slick. I need to disappear off while it's on there. And you have control, Theresa. Away you go.
Fantastic. Thank you very much, Angela. So just very briefly, we've touched upon it in the introduction, who we are at Lawspeed. We are specialists lawyers to the recruitment industry. We are dedicated to the industry, and we have more than 25 years experience of assisting the industry. So we help with everything from contracts to compliance, help with disputes, whether it's your candidates or your clients, fee issues, IR35. We help with all aspects of employment law. We help with training. We have an accreditation we can provide through standards in recruitment. We work with the trade body, the Association of Recruitment Consultancies, and we offer lots of helpline type options for our clients to come and speak to us whenever they have a problem. We work with recruitment companies, large and small, ranging across the industry. But that means we speak day in, day out to recruitment companies about what concerns them, what the issues are, which makes us ideally placed to see where there's a change in legislation, how it might actually have a practical impact. Now, the Employment Rights Bill was published about a month ago. It was within this 100-day time frame, which is very rushed for a piece of legislation. Usually it takes an awful lot longer than that to get something as huge as this and as wide-ranging as this drafted. It's not recruitment specific, this piece of legislation. It applies across all of employment law, but there are a few provisions which are more pertinent to recruitment than others. And there's three in particular that I would like to focus on today. And that is the changes to unfair dismissal, the 0 hours proposals, and statutory sick pay. Now, the bill itself is at more than 150 pages in size. So it also deals with a lot of other things, and I've put a few on the slide. So there's lots in there, perhaps unsurprisingly, politically, on trade union rights. We've got provisions in there about preventing fire and rehire arrangements. There are changes to flexible working coming down the line, which impact upon the reasonableness of a decision that somebody can't have a flexible element to their work. There's intention to change bereavement leave. So currently it's for a loss of a child, but to extend that a little bit and bring paternity from the day one of employment rather than having to have a 26-week period. There is also a plan to bring in a fair work agency, which follows on from the last government's plans as a single enforcement body. So the idea being bring together things like employment agency standards, gang masters, certain minimum wage teams at HMRC, things like that, bring them all together. But those parts, I mean, I could talk all day about those, but time constraints today mean that we may have time for them if there's questions, or it may be some of those elements for another day, perhaps. But the main elements that we need to focus on today, the first of these is unfair dismissal as a day one right. It's probably the most publicised element of the Employment Rights Bill, and potentially also the scariest for some people. I've heard a lot of people in business saying, no, this is not a good thing. But let's see how it's actually going to work. Now, today, if you were to let an employee go and they have 2 years service, then they have a potential right to claim unfair dismissal. You need to have that 2 years service generally. There are some exceptions. In some circumstances, you don't need to have 2 years because it's dismissal because of a maternity-related reason, or for asserting some form of statutory right, or asserting a trade union right. So there's like a specified reason for terminating the employment. But generally, it's 2 years. The proposal is that we lose that 2 years. We just go back to that being applicable from day one. So from day one of employment, proper processes need to be followed, and there needs to be a proper reason for terminating somebody's employment. That proposal has, like I said, caused a little bit of panic, a bit of fear. People saying, well, what do I do if someone just doesn't pass their probationary period? What if they just don't work out? Where's my flexibility gone? And to counter that, there is also a proposal in the legislation that we bring in a statutory probationary period. So this would allow a different approach during this probationary period. It's currently been suggested that this would be 9 months. That's not set in stone by any means. That's going to be subject to further consultation. But at the moment, the talk is about 9 months. Politically, some people think it should be less. Some people think it should be longer. So we'll have to kind of see where we end up sitting. But what it doesn't mean is we're just going from 2 years to 9 months. It doesn't mean that we've got a free rein in the first 9 months to just let anybody go for any reason. Instead, what it will mean is we have a lighter touch approach during that first 9 months and a less onerous process. So we don't know exactly how that's going to work practically, but I would envisage it could be something along the lines of, if you want to dismiss someone because of their conduct, you might not have to go through the full disciplinary process of written warning, final written warning, moving to dismissal. You may instead be able to have a less involved process, but still a process of some kind. There'll also still need to be a good reason for the termination relating to that individual. So we're still going to be looking at their conduct, their performance, and not meeting some form of expected standards as being the reason why you're letting that person go. There is going to be further consultation. At the moment, all we know is it's in 2025. Now, we don't know whether that's January or that's December. Could be or any point in between. My thinking would be it'll probably be earlier in 2025, just because it takes quite a while to do a consultation, get the responses, analyse the responses, act upon it. So I think it will probably be early on. But what the government has said is that they do not expect these rules to come into play any earlier than autumn 2026. So in practical terms, if you've already hired somebody and they're already working for you, they've probably got the 2-year window. Anyone you're taking on now is going to have less than a 2-year window, but the length of time they have is going to diminish up until autumn 2026. So just something that we're going to need to think about for any new hires moving forwards. But what is a big concern here is the impact on the recruitment industry of these rules, because the impact here is twofold. You've got the impact on your own internal hirings. So as an employer, if you have your own staff, you've still got to think about what you will do in terms of those staff. And what it's likely to mean realistically is that everything's got to be done a little bit earlier in the process. And there might need to be a little bit more process. An awful lot of employers are guilty of letting things drift up to 2 years, particularly if it's minor misconduct or just not quite meeting where someone should be, or just minor issues. But these new rules might mean that we're going to have to address these things a little bit earlier to sort of nip things in the bud, raise them, record them, so that if later on down the line or within this 9-month probationary period, you decide somebody's not working out, you've got something to fall back on. You've got the reasons, you've got something of a process followed. For some businesses, that might mean, there is enhanced screening. It might mean there is more training. It might mean there is more coaching ongoing at an earlier point, just to establish whether somebody is or is not going to work out for your business. But as I said, it's twofold. The recruitment company's got to deal with their own internal staff, but your clients are also going to be grappling the same issues and thinking about the same concerns they have. I've heard it suggested, multiple sources, that this is going to lead to less hires, that people are going to be reluctant to take on more staff. Now, personally, I don't necessarily agree with that, because I think if you need an employee, you need an employee. If you need someone to do the job, then it's unlikely you're going to say, well, I'm not going to hire them just in case they have a claim against me later on down the line. Also, unfair dismissal is manageable. It's a risk that is manageable within a business. But hirers might have those concerns. This might have an impact on perm hires. It might lead to potentially increased demand for temporary recruitment if it's short-term hires, so clients don't need to worry about process at all. It might mean that there is an increase in temp to perm, because if you've got somebody as a temp, then you've got the potentially 9 months as a perm. It's quite a long period of time potentially to be able to assess the suitability. So it's possible that some hirers will look more to those arrangements. It's also possible that hirers will decide that they need even more screening, greater interviews, more assessments to decide early on whether somebody is suitable or is not suitable for the role. And that's an area where recruitment businesses perhaps can assist clients, show their worth, that they can do a lot of this for clients, help them with it. So there are potential positive opportunities. I also mentioned on the slide rebate terms, because I don't think it's unrealistic to think that some clients, if they think they've got a 9-month window to assess someone's suitability, might potentially look for their rebate terms to match up with that. Not necessarily, and it's not written into the law, but it is, I think, a realistic possibility that you may get some hirers who will think about things like that. But what I will say is it's not all doom and gloom here. The whole rationale behind the changes to unfair dismissal is to give candidates and employees, applicants for work, security at an earlier stage. So if you've got 2 years service and they're thinking, well, I don't know about moving jobs because I'm going to lose that 2-year protection against unfair dismissal, that may fall away. It may make people more inclined to move. And I think anything that encourages candidates to move around can't be a bad thing for recruitment. So there is a potential upside to this, that the whole rationale behind it is to increase people's flexibility and willingness to move jobs. So there is something for us to look at there potentially. The next area of change to talk about is 0 or low hours. Now, I've got an asterisk on the slide next to low hours because we don't know what that looks like yet. In fact, everywhere on the slide that I've got an asterisk, we don't actually know what that looks like yet because we're going to get further consultation to see the detail of these things. But the proposal in the legislation right now is that for 0 hours or low hours workers, after a set period of time in work, then the employer will be obliged to offer a contract with guaranteed hours based upon an average of what they've worked during that period. The suggestion at the moment is this will be 12 weeks, okay, subject to consultation. So if somebody works for 12 weeks on a 0 hours contract, at the end of that 12 weeks, they'll be entitled to be offered a contract which is based upon the average of the hours they worked during that 12 weeks. There is a proposal that there must be reasonable notice of work requirements. I mean, this is purely intended to stop people getting a phone call saying, I've got a job for you and it's in half an hour, where they can't necessarily manage childcare or transport or finances to get to work. There is a proposal for compensation if shifts are cancelled or curtailed or moved to another location at short notice. This is really trying to get to overbooking, or, several people turn up for a shift of a morning and actually there is only a limited number of people that are required. It's probably mostly aimed at those sort of arrangements, but realistically, it could also address a situation where someone's booked in for an 8-hour shift, but after 4 hours, they're told they're no longer needed. Now, as the legislation is written today, agency workers are currently excluded from these rules. So you might be sitting there thinking, why is she talking about them if they're excluded? I'm talking about them because this is temporary, this exclusion. Government has been very clear that they do not intend to exclude agency workers completely from this. The legislation itself, excuse me. The legislation includes a power to extend the rules to agency workers, and we have a consultation. It's already open, and in fact, it closes in just a few weeks' time on the 2nd of December to talk about how these rules may be applied to agency workers. I've included a link on the screen to the consultation itself. It's quite short, but I think it's important that as an industry, we do look at these questions. But the consultation right now isn't looking at the detail of whether it's 12 weeks, what compensation is, not looking at those things. It's not even looking at whether these rules should be applied to agencies. It's instead looking at, if these rules are applied to agencies, who should be responsible for actually giving out these rights? So who should be responsible for issuing a guaranteed hours contract? The consultation says, should it be the agency? Should it be the hirer? It looks at short notice and says, well, who should be responsible if an agency worker isn't given reasonable notice of the shift requirement? The consultation suggests this should be either the hirer or the agency, depending upon who's actually at fault for not giving the notice. So if the hirer gives a booking to the agency and the agency doesn't do anything with it and books somebody in last minute, probably the agency's responsibility. But if the hirer has a really last minute booking, probably the hirer's responsibility. You can see obvious problems with that for the recruitment industry, particularly with short-term supply work. If you're providing someone to cover because somebody else has called in sick that morning, what is reasonable notice? Now, government intends to counter that with guidance, setting out what is considered to be reasonable notice, but that's next consultation. That's not this consultation. They're also looking at compensation, suggesting an agency should be the one liable to pay the compensation, but opening that up to look at them, how does that work practically? So we've got the key questions in this consultation on responsibility, but then we've also got that followed with Well, what's the practical implication? If a hirer is obliged after 12 weeks to issue a contract or to offer a contract to an agency worker, which would be a direct contract, where does this leave transfer fees? That's one of the questions in the consultation. If an agency is obliged to pay pay compensation to an agency worker because their shift is cancelled, then should an agency be able to get that back from the hirer if it's the hirer's fault it's cancelled? Should that be something that's just dealt with by law, so it's automatic? Or is it something we can leave to contract and just let agencies and hirers work it out themselves? There is in the consultation also a general question about any other thoughts about how this will work, which is quite an open-ended question. And I think there will be lots of thoughts, but it is again an opportunity to maybe shape things before it gets through to the next stage.
Could I just jump in there? Because if you just go back the slide, I did go into it last week and I put a post out saying, come on, everyone, we need to make sure that our voices are heard. And one of the thoughts that I ended up putting was the way that the questions were written were very much that you couldn't choose a negative is probably the best way of putting it. It was always still likely to go ahead when you looked at what you had to click to start with, but there were opportunities, like you say, for the other thoughts and for any comments. So my worry is if they just sort of amalgamate all of the answers from the click buttons, it looks like I was being really positive about it, but actually the comments weren't necessarily. So I just want to put that out to people as well. Make sure you put your comments and you put in those any other thoughts, because otherwise for me it seemed a little bit biased. That's all I'm going to say.
Yeah, it's definitely on the basis that it will happen. That consultation is written, and you're right. It is like click either or. Should the agency be responsible? Should the hirer be responsible? When in reality, it might need to be a sort of an either or approach, depending upon who is actually, who's more appropriate. If you're an agency that supplies people day by day to multiple different hirers, then it might be realistic that an agency was the one dealing with the hours. But if you supply somebody on a long-term assignment for those whole 12 weeks to one hirer, even if it is technically 0 hours, then it might well be that it's not, it's the hirer's responsibility. This might be more like the agency worker regulations. That sort of
a really good example there, Theresa, actually, because that just shows you straight away it's not a one size fits all. We'll see.
No, not at all. That's okay. The third element I wanted to mention today was statutory sick pay. And I think this one's gone under the radar a little bit. But for our clients, we've had lots of people saying to us, actually, we're quite concerned about this. And currently, if an individual's entitled to statutory sick pay, it's only paid from the 4th day they're off. There are 3 waiting days. And if your average earnings are below £123 a week, then you're not entitled to statutory sick pay anyway. Now, the proposal is that this will apply from the 1st day of absence. So if someone calls in sick on day 1, even if they're only off for 1 day, they would be entitled to statutory sick pay. And there is a proposal that the lower earnings limit will be removed, but if you earn less than that, you'll get your statutory sick pay as a percentage. So it'll be proportionate. So because you can't really have a situation where somebody earns more in statutory sick pay than they would do if they were working. So it's intended to address that proportionately. And a lot of businesses, particularly in recruitment, are looking at this and saying, well, this is just an additional cost for us. We can't get this back. We're not going to get this from clients. We're not going to get this from the government. This is just a cost for us. And a worry that even though it's only just under £120 a week statutory sick pay, if that was on volume, that could add up to quite a bit taken out of margins. So there is a little bit of a concern about this one coming down the line, but there is again intended to be further consultation on the detail of how this will actually work. The other change here is that it's intended that statutory sick pay will fall within the remit of this new Fair Work Agency. So the Fair Work Agency will be able to enforce these or investigate complaints rather than it necessarily having to be treated as a deduction from earnings or going back to the DWP as it potentially does now. So that might be a good thing. It might actually speed up the process a little bit to enable it to be dealt with that way. The other question we get a lot at the moment is this it? Is this all we need to worry about, or is there more coming down the line? And unfortunately, there is likely to be more coming down the line. When the Employment Rights Bill was published, there is also a document published alongside it called the Next Steps to Make Work Pay. Now, this follows on from in the last election, the Labour Party produced a document called Make Work Pay. And this is sort of a follow-up of how we're actually going to do this. It talks about the Employment Rights Bill, gives some explanation of what's happening, but also then has a whole section on what else government wants to do. And that includes looking at parental and carers leave to see whether these are fit for purpose any longer or whether adjustments need to be made. They want to look at health and safety and in particular workplace surveillance. They want to look again at self-employed rights, some of the focus being on whether self-employed individuals should be entitled to receive a written contract, and also looking at late payments. There is questions around public procurement, potentially extending Freedom of Information Act requirements to those who are working on public contracts, but also in the tender processes, making employment rights compliance a significant factor. Now, we don't know what any of these are going to actually look like because they're all commitments to review and to consult. But it's realistic. We can see potential change coming down within this parliamentary cycle. But the big one is single worker status. Because there is a commitment to look at single worker status, to look at people who have the status of worker and potentially amalgamate them with the status of employee. So give workers employment rights. The biggest group this will impact upon is PAYE temps, because the vast majority of PAYE temps are engaged on worker contracts where they have rights to minimum wage, holiday pay, not to be discriminated against, but don't have rights to claim unfair dismissal or to minimum notice periods, or not the same rights to return to work after maternity. There are differences between the two, and that could have a significant impact on recruitment. But it's very much a watch this space type thing at the moment, because we don't have the consultation, we don't have the plan, but that will be one the industry will be very involved in, because I think it will affect recruitment more than any other industry. The last point I put on the slide is about the recent budget, because I think it's also worth mention of something that's coming down the line. Now, all the headlines in the budget were about the minimum wage increases and the employers' national insurance changes, and for recruiters, the increase in costs of supply. But there was also mention in that budget about umbrella taxes. Now, if you recall, over a year ago, there was a consultation, like last summer, there was a consultation on umbrellas and whether there should be regulation of umbrellas, whether there should be mandatory due diligence, whether there should be tax debt transfer in event the umbrella company doesn't meet its obligations. And this is kind of the response to it. So there's an indication that we will get something in the springtime, strengthening the responsibility that agencies have for umbrellas if they don't deal correctly with PAYE. Again, we don't have the detail because this will come in the finance bill that will come in the spring. The only detail we have is that the intention is this will be for 2026.
I'm not sure if you've paused there or whether it's me. Louise, I can see that you're in the chat, so if you could let me know if I'm talking over Theresa or whether it's me. I'm not sure if you've paused there or whether it's me. It did pause. Thank you. Let me pop myself down there then, as I'm here. And let's just focus that over to there. There we go. So Theresa's dropped off. Hopefully she'll be coming back. I'm guessing I suddenly saw the internet bars come up there, and that usually means that there's an issue. So if I can see her come back on, when I drop from there, she had, I think, got to the last page. So I'm just going to double check to see what's next, if there is anything there. Oh, top tips. Okay, I can do those. Let's go for it. I did used to train all the legal stuff, as I said, but it's been a long time since I have. But let's go for that first bit on the left there. Participate in the consultation process. Let your voice be heard. I've put in the chat on LinkedIn and onto Crowdcast here that consultation link that she had on the slide. We definitely want your viewpoints. Don't leave it. This is a bit like sort of, you've got to vote, use it, because this will impact our business, and it can be for a positive. There were some lovely things on the slide with regards to the impacts around the probation periods and more training. Whoop, whoop. Yep, I was there for that. I'm happy with that because it's going to mean people performance-wise are going to get the best out of it. They're not going to be left for ages and then sort of managed out of the business, which is not a great way. They're going to deal with that to start with, give them the support that they need. I'm all for that. But do keep up to date with the changes. I'm really glad to see with this one, because there is so much coming down the pipeline, that actually there's a lot of information out there at the moment. A lot of people talking about this, which hasn't always been the case when we've had major updates through the legal process before. So great to see that. And as I say, what I'm hearing is that there are adults in the room. The government does want to hear your views. They are taking things into account. So let's take advantage of that while they're willing to listen. What do we got? We've got start process changes soon. How do you deal with the new starters, and especially then if they're going to change? But remember, like it did with the first one, it's 2 years' time that it's likely to come in. So yes, you don't have to panic yet. If you're old enough, don't panic, Pike. Might mean something to you, but it is about talking about it and starting to understand the processes and seeing how this will change for you, and having the conversations, talking to your customers around what they're doing, what's their knowledge, how's it going to impact them. Booking those service review meetings in November and December, perfect time for it, to review the year, what's gone on, what's worked, what hasn't, what's coming up. And you can share this knowledge and have an adult conversation about the impact that it will have on businesses and how you can work together with your customers to support that. Think about how you can reassure nervous hirers. Oh, I think Theresa's back. Wonderful. Let's bring her back on. And again, yeah, because we don't want people to suddenly go, oh, well, I don't know what's going to happen. I'm not going to hire. No, because if you needed to hire, there was a reason for it. So let's have the discussion. Let's clarify what their hesitations are, and then we can pick it up from there. I don't think anyone noticed, Theresa. I think we're fine.
Sorry, I think I was talking to myself for a little bit then. I think everything just froze and I carried on talking. So,
well, I never know whether it's me or whether it's the guest.
Yeah,
so
I'm not sure.
I'm sort of talking, going, can anyone hear it? And they're fine, and they carry on. I'm talking over them, but no, we were good. So I'm halfway through your top tips. So we're down to other commercial offerings, if you want to pick it up from there.
Yeah, I think it's just about making sure that you're prepared for these things, but making sure that you talk to hirers. They may be scaremongering, they may be panicked, they may be nervous about these things, but there can be a lot of reassurance. And I mean, one thing to really remember on the unfair dismissal changes is that all that's changing is the timescale. You know, if you have a good reason to let somebody go and follow the right processes, then you shouldn't have an unfair dismissal claim. We can't protect against the vexatious claimants and things like that, but in reality, you shouldn't have a successful claim against you if you do things properly. So I can imagine clients might need a little bit of reassurance, but might need to look at other offerings such as like temp to perm or temp supply elements to get around certain things.
It's coming back with that question, if they are, isn't it? Saying, well, Are you thinking of unfairly dismissing anyone? And they'll be like, no. Well, there you
Yeah,
go. You don't need to worry
yeah.
about it then.
You
Follow the
can, I mean,
process, you'll be
it,
fine.
it, it generally is with any dismissal. If you've got a good justified reason for letting somebody go and you follow the proper processes, and that in some extent brings the final point in the slide, is get a bit of advice. Because I always say to people, ask if you make a phone call and have a bit of a chat with me first, then I can tell you where you're going wrong, and that will save you a hell of a lot of money rather than dealing with it after the event and trying to sort out the problem after it's happened. So, sometimes it's just somebody ringing me up and I say, actually, if you just need to do that slightly differently, or actually you just need a little bit more time, a little bit of something else in the process, you protect yourself. So there are things that can be done. But one of the points I've got on the slide there is long-term contracts.
Yeah.
I was working with a client a few days ago who was signing up to a contract that was 3 years in duration and then potential renewals.
Right.
But in 3 years' time, we might be looking at a different position in terms of single worker status. We might have extra costs of supply. We might have things to factor in. So a bit like people dealing with the national insurance increase that came in the budget, if you've got something built into your contracts already that allows you a mechanism or a process or even an automatic right to change if your costs of supply increase or something's got to be varied because of a legal change, might put you in a better position than having to go to a client for just a pure negotiation. So it might give you some options there. But the other thing we've got on the slide there is, and you've mentioned already, Angela, is most important thing at this stage is participate in the process and get your voice heard, because it's people who work in the recruitment industry day in, day out, who are ideally placed to say, this won't work because, or this is where I see a practical difficulty, and now's the time to address those things.
Yeah, I mean, if one of those questions where when we looked at it, I mean, there were quite a few. Give yourself at least 15 minutes to do that consultation bit. I think that's probably a good time frame. But there were a couple on there. It's just like, this really, I can't see this working. I can see more issues with it than it's going to solve. And therefore, that's the knowledge that we need to share. And if everyone's saying that in the consultation period, then they're going to take notice, aren't they? Go, actually, I think we're on hiding to nothing with this. We need to adapt it. It might not change totally. It might not go away. But as long as they can see where the problems are going to be beforehand, before they implement it, then we're happy with that. And it seems like they are willing to. Okay, well, due to our little glitch, unfortunately, we haven't got time for questions. I was keeping a lookout for them, but I couldn't see any immediate ones, and I certainly jumped in when I had a query. But no, that's brilliant, because we've got your LinkedIn on there, Theresa, so if people have got a question, you've got your number on there as well. That's fabulous. This gets downloaded into our Meet the Expert course, which we actually have 8 different courses. This is just one of them, and this is session 48. So there's 48 sessions like this of free training, consultation, consultancy for you to learn about everything to do with our industry on pretty much every topic you can think about in those 48. So I've put the links in there for people to be able to sign up for that. So that's free, signing up in the Recruiting Gym for those 8 courses with about 500 sessions altogether. So definitely get involved there as well. We're here to support, we're here to help, and it's people like Theresa that share their knowledge that makes it what it is. So thank you so much, and thank you for so professionally just dealing with that and just coming straight back in. Wonderful.
Thanks very much, Angela, for the opportunity to talk to everyone. And like I say, my contact details are there. If anyone wants to come and have a chat about these things, then very welcome to do so.
I think you'll get a few. Wonderful. We'll head into the green room then. Have a great day, everyone.